Arif Medical is a private healthcare company operating general wellness clinics under the Arif Plus brand. In 2021, it introduced a new medical partnership growth scheme, inviting general practitioners to jointly manage selected clinics. Under the MPGS agreement, partners had access to Arif system and were subject to restraint the trade clauses and confidentiality obligations. However, several issues have arisen.
Good day everyone, I'm Gayatri Saravanan and today I will present two legal issues related to Dr. Azlan Yusof departure from Arif Medical Sdn Bhd. The issue one is the restraint of trade clause in the consultancy agreement is enforceable? The first issue is whether the restraint of trade clause in Dr. Azlan's consultancy agreement is legally valid. Under Section 28 of the Contract Act 1950, any agreement that restrains someone from engaging a lawful profession or trade is void, unless it falls within limited exception or is considered reasonable. One relevant exception under Section 30 of the Partnership Act 1961 allows former partners to agree not to compete, but only within reasonable limits. Courts have been clear on this. In Polygam Records versus The Search, a 2-year restriction was struck down, and in Thomas Cowan against Orme, a 3-year term was also deemed too harsh. In contrast, Herbert Morris against Saxelby upheld the clause where the restriction was reasonably to protect business interests. In our case, Dr. Azlan's restriction lasted for 5 years and covered a 30-kilometer radius, which seems excessive. Arif Medical may argue that it was to protect for the goodwill, but Dr. Azlan was only a consultant and not a partner or an employee. Even if the medical partnership growth scheme resembles a partnership, it must meet the legal requirement under the Partnership Act. Given a wide scope, the clause is likely unenforceable under Section 28 for being overly broad in both time and geography. Any duty of confidentiality or loyalty. The second issue is whether Dr. Azlan breached any duty of confidentiality or loyalty. Even without a written confidentiality clause, professionals have an implied duty not to misuse confidential information. In Coco against A.N. Kalk, the court outlined that to prove a breach, the information must be confidential, shared under circumstances of trust, and misused without permission. Similar principles were also applied in Schmidt Scientific against Ong Han Swan and Demerco Express against Patricia Lee, where the employees used insider knowledge to create competing businesses. In Dr. Azlan's case, he opened BioCare Wellness, a similar clinic, just 2 months after leaving and only 10 km away. The clinic system and branding closely resembled Arif Medical's, including the use of similar patient apps and reminders. This strongly suggests that Dr. Azlan relied on confidential operational knowledge from his time at the Arif Medical and thus likely breached the implied duty of confidence and loyalty. As in conclusion, the restraint of trade clause appears unenforceable due to its excessive scope. However, Dr. Azlan's action has raised serious concerns about the misuse of confidential information, which may form the basis for a legal claim by the Arif Medical. Thank you.
Whether the agreement between Arif Medical Sdn Bhd and Post Diagnostics Sdn Bhd is valid and enforceable. According to Contract Act 1915, Section 10, contracts are valid only if they are made with a lawful consideration and for a lawful object. Therefore, Medical Act 1971 stated it is required that all diagnostic health screening software be registered with the Ministry of Health. In PJD Regency Sdn Bhd and Tribunal Tuntutan Pembeli Rumah and Anor and other abuse, the Federal Court held that even though the developer had breached certain statutory requirements under housing regulations, the agreement itself was not automatically void. The court distinguished between a contract that is illegal in its object and one where the manner of performance violates the law. To apply to this situation, the contract between Arif Medical and Post Diagnostics suffers from significant weakness, particularly regarding the ownership of the software, the scope of exclusivity, and data integration rights. Under established principle of contract law, particularly in the context of Section 10 of the Contract Act 1915, uncertainty in essential terms can render a contract or part of its award. For the conclusion, the agreement between Arif Medical and Post Diagnostics is likely unenforceable due to uncertain terms, illegality from regulatory non-compliance and grant misuse, and an unlawful restraint of trade if exclusivity is enforced. Arif Medical may also face penalties for using unregistered diagnostic tools. Legal remedies against POS or BioCare are limited, but reporting the breach to the Ministry of Health or grant authorities is advisable. Since this term go to the heart of the agreement, the lack of clarity likely undermines Arif Medical's ability to claim any enforceable exclusive rights over the software, especially now that it's been used by BioCare Wellness Clinic. Further complicating matters is the breach of public grant conditions. The software in question was partially developed with funding from the National Digital Health Programme 2020, which imposed a 5-year non-commercial use condition. Pulse diagnostic licensing or provision of the platform to BioCare appears to be in direct violation of this condition.
Okay, so let me paint the scene first. Now think of Dr. Sarah, who just finishes a project with Arif Medical, and they exchange a few emails, nothing formal, just a casual understanding that she won't join a similar health programs for a year. No contract, no signature, just an invisible handshake is what we're gonna call it today. But now Arif Medical wants to enforce that promise. So it raised a legal issue whether this 1-year exclusivity clause is valid under Section 28 of the Contracts Act. And now in Norton against Maxim, we can see that the court agrees a restraint can be valid if it protects real business interests and is fair in time and scope. However, the contrast can be seen in La Cafa against Loop, the Chatham against T-Life case, where the court threw out a similar clause because it was too broad, unclear to the point it became unnecessary. So what about Dr. Sarah's clause? It has no defined limits, no justification, and no proof she even had access to sensitive information. So under Section 28, it's not just weak, it is also unenforceable. Okay, now let's dive in deeper, and let's say Arif wanted to enforce it. But then let's question if there was a valid contract in the first place. So under Section 10, we all know the basic of contracts: offer, acceptance, consideration, and intention to create legal relations. But in this case, there was no signed agreement or no formal terms. No formal terms equals to no consideration. So it's just vague emails. And in the case of an STP against AIDA, the informal talks and partial cooperation didn't amount to a contract because there was no clear intent to be legally bound. Same with Guthrie Wah against Malayapan. The court ruled that if key terms are uncertain, the whole agreement falls apart. So that's exactly what we have here. And the truth be told, the handshake was invisible, and so is its legal weight. And we can see that there was no valid contract, and even there was, the clause is already void under Section 28. So all in all, Dr. Sarah is not bound, and Arif Medical maybe next time get in the writing.
Whether Dr. Amir's proposal about the plan to set up a new similar clinic constitute an anticipatory breach or a breach of confidentiality under Malaysian contract law. Dr. Amir, who is still officially employed as a consultant with Arif Medical, has prepared a proposal for a new clinic that substantially mirrors the MPGS program. Although he has not formally left his current post, his activities raise concern about potential breaches and misuse of confidential information. According to Section 40 of the Contract Act 1950, an anticipatory breach arises when one party refuses or expresses an intention to not perform their contractual obligations before the performance date. This enables the opposing party to treat the contract as breach even before the actual breach happened. Mentioned under Partnership Act of 1961, specifically Section 30 and 33, partners have the fiduciary duties to the partnership. These include responsibility for good faith, loyalty, and confidentiality. Partners are not permitted to utilize partnership property, information, or opportunities for personal advantage without approval. In the case of Melaka Sdn Bhd and Visioncare Sdn Bhd and ORS, the High Court reaffirmed that even without written confidentiality clause, a person who has access to sensitive business material must not use for their own benefit. In similar vein, the court acknowledged Zulkifli bin Hussein case that the former workers and by extension business partners may be held accountable if they improperly use confidential information to engage in unfair competition. To apply in this situation, although Dr. Amir hasn't quit or started a rival clinic yet, it is concerning that he has created and distributed a business plan that substantially resembles Arif Medical's exclusive materials in terms of layout, branding, and patient journeys illustration. These acts may indicate a clear desire to breach any clause, even though he hasn't done so yet. This could be regarded as anticipatory breach under Section 40. Given that he is still a partner and obligated to fulfill fiduciary duties under the Partnership Act, this is significant. Furthermore, according to the logic in Melaka case, Dr. Amir has inferred obligation and confidentiality because he has the access to proprietary marketing, design, and operational documents, even in the absence of clear non-disclosure agreement. And he might have already violated that obligation by including those elements into his proposal. According to Section 30 of the Partnership Act, his actions might also constitute an abuse of partnership property because Arif Medical created the branding and operational model not for personal commercial use. So, in conclusion, even though Dr. Amir hasn't officially broken the MPGS agreement or launched a rival clinic yet, his actions speak it all. Especially the distribution of the proposal that closely resembles Arif Medical's intellectual information might amount to anticipatory breach and confidentiality violation.
Arif Medical thought to pursue prompt legal action against Dr. Azlan Yusuf for violating the agreement he signed. His contract expressly stipulated that he could establish or assist in operating a rival clinic within 30 km of an Arif Plus branch from a period of 5 years from the date of his departure. However, 2 months following his departure, Bayu Care Wellness Clinic opened its own door less than 10 km away. It looked like almost the same as Arif Plus. Uses former Arif Plus staff and even seem to have contracted Arif former patient. Arif should get a lawyer to examine if the clause is reasonable in Malaysian law, especially the distance and time requirement, and then ask the court to enjoin Dr. Azlan and possibly award damages. The court could also legally rule that clause is valid, which would be easier to enforce in the future. Apart from negotiating with Dr. Azlan, Arif should have clear rules in all its contracts about what doctor and partner can and cannot do after they leave. This is especially important since Arif has a very lenient contract with Dr. Sarah Khalid, who went on to work with a rival online health service, even though there was a gentleman agreement that she would not do this for 1 year. Nothing was in writing. Going forward, even for short terms or part-time work, Arif need to have written contract with non-compete agreement and rules about non-poaching, patient or employee upon termination. To avoid the same issue with current partner, Arif should also be watching for signs that they are planning to resign and establish rival business. An example is Dr. Amir Iskandar, who has not decided anything in breach of rule yet, but who planned for a new clinic. Seems very much like Arif Plus document. Arif should send him a warning letter reminding him of his confidentiality agreement that companies should also put in place a system to police partner external activity such as screening any pitches they make to investors and include regular reporting and audit in their agreement to prevent secret agendas. Arif also needs to settle a legal dispute over health screening software it uses, which has created with the help of technology partner. Pulse Diagnostic, Malaysian law has required registration of such software with the Ministry of Health since 2022. Arif never did that, nor did Pulse. That put Arif at risk of breaking the law. The original deal with Pulse was not reviewed by lawyer and did not clearly outline who owned the software or how it meant to be used. Arif must now hire an attorney to examine the agreement, rectify an ambiguous section, and make them conform to all law. Arif must also notify the Ministry of the situation and seek permission to register the in the event it is determined that Pulse disseminated the software to BioCare unlawfully. Arif may be forced to take legal action. This can constitute a severe violation of contract or even fraud. What is worse is the fact that the software was partially financed by a public grant, and one of the conditions was that it could not be utilized for profit making for 5 years. Arif can sue in civil court, seek damages, and report the authority with the Malaysian Digital Economic Corporation to dismiss use. This is not just needed to recover losses but also to protect Arif's future government support opportunity. Finally, Arif must do more to protect its own brand, system, and electronic tool. These, like the name of the clinic, design, computer program, and treatment protocols, are valuable and must be legally protected through trademark, copyright, or agreement of confidentiality. Subsequent agreement with supplier and partner must also contain a clear statement that this material belongs to Arif and cannot be duplicated or used by other party once the agreement is dissolved. This will allow Arif to prevent other individuals from misusing or stealing their work and retain their competitive edge in the healthcare industry. Other individuals from misusing or stealing their work and retain their competitive edge in the healthcare industry.